Okay, members of the jury, just a reminder, if we take a 10-minute break, be here 10 minutes. Even if I'm not here, I need the jury to be here because I don't like walking out and not having the jury here, so just moving forward best we can. Mr. Busby.
Mr. Mateer, you told us Ken Paxton was your friend.
He became my friend, yes.
And you were trying to protect him?
That's correct, sir.
And you were trying to protect him from himself?
Correct.
And when you found out that this young man, Brandon Kamek, had sent a subpoena to a bank, you guys sent everybody on the 8th floor home and had a meeting, right?
I don't recall us sending everybody home. I do recall we had a meeting.
And in order to protect Ken Paxton, what you did was then call the FBI, right? That's how you protected your friend.
That's not correct, sir.
Did you not go to the FBI thereafter?
Not that day, sir.
What day?
The next day, sir.
Okay. Did you talk to Ken Paxton before you went to the FBI?
General Paxton was out of state.
Did you talk to Ken Paxton before you went to the FBI?
I talked to him on the 28th, yes.
After, sir, listen, you found out that Brandon Kamek had served a subpoena on a bank, right? Right?
That is correct, yes.
You thought it was a crisis situation, right?
That is correct, sir.
You rallied the troops together and had a meeting, right?
We had a meeting, yes, sir.
The next day you went to the FBI.
We did, yes, sir.
Did you, after your meeting, talk to Ken Paxton?
I did not talk to Ken Paxton.
Okay, so in order to help your friend, a guy that had given you a really plum of a job, instead of asking him some questions, you instead circled up and decided to go to the FBI. That's what happened, right?
I did have conversations with General Paxton.
Not after that meeting, right?
Not after the meeting on the 29th, correct, sir.
You had no clue that Brandon Kamek had received a second referral from the DA's office, did you?
I did not.
You were wondering why they were serving subpoenas on a bank when the complaint that you knew about had to do with the FBI and the magistrate judge, right?
That's correct.
You had no clue that there had been a second referral from the DA's office directly to Brandon Kamek. Isn't that right?
That's right. No one had shared that with us.
So you thought this Kamek fellow is sending subpoenas to banks related to some FBI thing, right?
I didn't know what he was doing.
You know how you could have found out? You know how you could have found out? You could have picked up the phone and called your boss and said, hey, boss, what's up with this Brandon Kamek? He sent a subpoena to a bank. And he could have told you, well, I have the authority to sign a contract because I am the elected AG, and he's sending subpoenas based on a second referral. You could have done that, right?
I could have done that.
But instead what you did was rally your troops, get your stories together, and go to the FBI. Isn't that right?
That's not how I'd characterize it.
Did you also talk to Dick Trabolsi?
Not at that time, no.
How soon after that did you talk to Dick Trabolsi? You know who I'm talking about, don't you?
It's the leader.
Tell us who he is.
I believe he's the leader of Texans for Lawsuit Reform.
He sent you a text, didn't he?
He sent me a text after I resigned.
A text of support?
I got many texts of support. He was one of them, yes.
Where are your texts, by the way?
I don't keep texts.
What do you mean by that, you don't keep texts? You deleted your texts?
After I left the Attorney General's office, when I'm no longer employed at the Attorney General's office, I didn't keep texts.
You didn't think anybody might want to look at your texts?
I adhere to zero inbox policy. And I think anybody who's ever worked for me knows that.
Is that right?
That's right.
So just so we're all clear, and everybody's watching is clear, you were having conversations with the leader of Texans for Lawsuit Reform, who was showing support for you after you'd went to the FBI and resigned, right?
I had one text message that I received from Mr. Trabolsi after I resigned.
How did he have your phone number? I thought you weren't the kind of person that would talk to people like that. How did he have your phone number?
A lot of people have my phone number. Probably General Paxton gave it to him at one time.
You know we do have some of your texts, don't you?
I mean, I assume you do if others produce them. Yes, sir.
Yeah, we don't have any from you because you say that you delete them. Tell me how you delete them, by the way, because that seems like a challenge. How do you delete every text that's sent to you?
I look at email, I look at texts every day, okay, within a 24-hour time period. If it requires an action, I then note it as a to-do item. If it's unrelated to anything, then I delete. That's been my policy for a year, sir.
Wow, you worked for the government, right?
Well, this was after I worked for the government.
Right, after you were no longer working for the government, you deleted your texts. Is that what you're telling me? Or you delete them real time?
I delete them basically real time within a period of time.
Did anybody else in the office do that, or was that just your practice?
Well, the other person that probably did that was the Attorney General.
You think so?
Yeah, I think so.
Did he have a burner phone, by the way?
You know, someone mentioned that to me at one time.
Who mentioned that? You read about that in the newspaper?
No, I don't think I read about it in the newspaper. It would have either been Mr. Wicker or Mr. Rylander.
Mr. Ricker didn't mention it to you because he was questioned. He said he didn't know what a burner phone was. No. Who told you that he had a burner phone?
Again, my best recollection would have been Mr. Wicker or Mr. Rylander.
Did you ever see a burner phone?
I know the Attorney General had several phones. I don't know, what a burner phone. You
know what a burner phone is. This would be a burner phone. You can go to 7-Eleven, you can buy it, you use it for a certain amount of minutes, you throw it in the trash. That's called a burner phone.
Okay.
You ever see Ken Paxton with a burner phone?
He had a flip phone.
Did you ever see a burner phone, one that he bought at 7-Eleven so he could do some sort of illicit business?
I don't know, sir.
Okay. How about a secret email address? You ever see him with a secret email address?
He had a Proton email address.
Didn't you have a Proton email address?
I sure did, yes.
Oh, goodness gracious. So he had the same kind of email address that you had.
Okay.
We've been told that's a secret email address, but you had the same kind of email address, didn't you?
I think a lot of people had them.
Sure.
I think your co-counsel has one.
They do have it. You know why people use a Proton email address?
Because I know why we did, because we were concerned that Google might be monitoring our conversations. We were investigating Google.
Right. And also Ken Paxton and several others went to China, and they wanted to make sure that their email did not get hacked, right?
Okay, correct.
But yet, this board of managers, the House of Managers, claims that that's some kind of secret, weird thing to do, and everybody in the office was doing it. Isn't that right?
Well, I don't think everybody in the office was doing it, but there were some, yes.
Sure. Now, back to your text. Just so the court is clear and the jurors are clear, your testimony is when you receive a text, if it needs action, you note it, and otherwise you delete it.
That's correct.
And you still do that now?
I do.
Well, the good news is Mr. Brickman didn't have that same practice. Let's look at what is marked and in evidence, AG 170. And Eric, if you don't mind, go to the page is Brickman 187. Let's put it on the screen so the jurors can see it. What we're going to look at, sir, is a text string that you were on with Brickman and several others, okay?
Okay.
I need you to speak into the mic, please.
Yes, sir.
Okay. Eric, let me know when you're ready. Go to 187, Eric. We're looking at AG Exhibit 170. $187. All right, here's a text you sent at 3:02 p.m. on 9/29/2020. Is that right?
That appears to be correct, sir.
You said, we have a major problem. The kid has served a subpoena on a bank, showed up there in person at the bank, right?
That's what it says, sir.
And you were thinking in your mind, why the devil was he serving a subpoena on the bank? Nate Paul's complaint has to do with the FBI, right?
That was one of the things I was thinking, sir.
Because you had no clue that there had been a second referral, true?
I did not know there was a second referral at this time.
Is this the first time that you had found out that the kid, you're referring to Brandon Kamick, right?
I am referring to Mr. Kamick there.
And you didn't say, hey, Brandon Kamick, you said the kid. Everybody knew who you were talking about, right?
That's right.
Okay. So Kamick wasn't a surprise, was he?
Kamick wasn't a surprise in the sense that we knew who he was. That's correct.
Sure. And you actually got a copy of his contract too, didn't you?
At some point, I got a copy of the contract, but not through the DocuSign, no, sir.
Right. I mean, I know and we're going to talk about your bureaucratic procedures. What did you call it? Your executive action memo? What do you call it?
Executive approval memo.
Yeah,
memorandum.
executive approval memo.
Mm-hmm. Yes, sir.
Some procedure in writing put in place of how things should work at the AG's office.
That's what it was, yes.
Right. It's in some policy manual.
It's a policy, yes.
Okay. It ain't the law, though, is it?
No, it's not the law.
No. The power of the Attorney General derives from the Texas Constitution. Is that not true?
From Texas Constitution and Texas law statutes.
The Constitution is what gives the Attorney General the power to act. Isn't that right?
The Constitution and the statutes passed by the legislature, yes.
Your power to act, if any, derives directly from the AG. Isn't that right?
It's derived from the AG, but it's also derived from the statutes.
Yeah. You're not authorized to take his name off his letterhead, are you?
Am I authorized to take his name off the letterhead?
I'm sorry? Is that a question? Or are you saying...
I'm repeating your question to make sure I understand it. Could you restate it?
I can absolutely restate it. You, as deputy, as first assistant, are not authorized to remove your boss's name from his letterhead, are you?
I don't know if that's true or not.
Did you not look? I mean, aren't you a lawyer? Isn't that something you better look at before you do it?
I don't recall doing it, sir.
You don't recall sending correspondence with the Attorney General's name removed?
I do not.
You wouldn't have done that, would you?
By implication of your question, it must have happened, but I don't remember.
Oh, it happened. My question is that legal?
I don't know it's illegal.
Well, did you check before you guys were sending correspondence without your boss's name on it?
I didn't personally check, no.
Well, I thought you were a rule of law guy. Isn't that what you told us? I'm a rule of law guy.
I am a rule of law guy.
Okay, rule of law guy. Is it legal to send out correspondence without your boss's name on it? Official correspondence from the AG's office?
I don't think it's illegal, no.
You don't think it's illegal?
I do not.
Is that how you decide your legal analysis, is by just whether you think it is or not?
No, it's supposed to be based upon what I believed and what I know about the law.
Well, what do you base that on? Why don't you inform us?
What I believe is, what I do recall is, before I became first assistant, the prior first assistant, actually one of the complaints that the Attorney General had with the prior first assistant was that the original letterhead didn't have Mr. Paxton's name on it.
So you knew that the official letterhead, according to General Paxton, had his name on it. That's what he insisted upon, right?
Well, he insisted on it, and I don't know about the word official.
Mm-hmm. And yet, you were party to correspondence where his name was removed.
That I don't know, sir, but if you're saying that, then I must have been.
Mm. So let's make sure we're all clear that you did get the contract, because it's in the text even. Eric, turn to same exhibit, AG 170. Go to Brickman 180. Vassar texted you a copy of the executed contract, didn't he?
It looks like on October 1st.
Yep. Did you go back then? Was that the same day you met with the FBI?
No.
What day did you meet with the FBI?
I believe we met with the FBI on the 30th, sir.
Okay. So did you go back to the FBI and say, hey, you know what? I made a mistake. There actually is a contract. My boss signed it, and there's a second referral. Did you do that?
Not on October 1st.
You went to the FBI uninformed. Isn't that true?
No, I wouldn't say that, sir.
I just want to try to get the timeline because the jurors may wonder. You spoke to the FBI about, what do you call it, a good faith belief that a crime had occurred? Is that what you said? Did you go to the FBI with a good faith belief that a crime had occurred? Is that what you told us?
That's correct.
Okay. And that was on October the 1st?
No, sir.
What day?
That was on the 30th.
September the 30th?
Yes.
Okay. That's when you called Mr. Sutton before that, right?
I didn't, no.
What?
I had not, no.
One of you did?
I believe that's true, yes.
Okay. One of the group called Mr. Sutton before that, right?
I believe that's true.
Okay. We'll get to that in a minute. But so on September 30th, you went to the FBI and you made your good faith complaint, right?
We told the FBI the knowledge that we had.
Did you then go back and give them a copy of the actual signed contract from the duly elected Attorney General?
I did not.
You did not?
I did not.
Did you go back and tell them, hey, you know what, there was actually a second referral. It didn't even come into our office. It, in fact, went directly from the DA's office of Travis County directly to Brandon Kammick. Did you tell them that?
Not on October 1st.
Did you tell them at some point?
I think at some point we did tell them that,
Okay.
yes.
Did they indict Ken Paxton?
As far as I know, they have not.
Okay, so let's try to get our timeline right. That was September of 2020, and this is September of 2023. It's been 3 years.
Your math is correct.
So in 3 years, they've done nothing with the information that you provided them. That's the subject of this impeachment, right?
I don't know what they've done, sir. You
Well,
can ask them.
Well, they certainly are pretty good about letting us know if somebody's been indicted, aren't they?
That's your area. I would assume we would. Well, I don't know.
Okay. Your Honor, I know you were concerned about timing. This might be a good break for me. If you want to do it, it's up to you, though. Of course, it's noon. I'm getting ready to go into another topic, and it's going to take some time.
We have a good half hour, 45 minutes.
Okay, I'm all for it.
Keep going.
You know, before I get into some of these other areas, like the Midi Foundation, which you approved of the intervention, right?
I did approve, yes, sir.
The Midi Foundation, where you approved to investigate them, right?
I did sign that memo, yes.
I mean, let's just make sure we're all clear here. One of the articles of impeachment, in fact, the very first article of impeachment, has to do with the AG's office intervening in the Midi Foundation lawsuit, right?
You know, if you say so, I'll accept that.
I know you're a rule of law guy. Let's look at Article 1, make sure we're all clear. Article 1 of the impeachment, first article. Just confirm with me, if you would, Mr. Mateer, that is, in fact, the very first article of impeachment that we're here arguing about.
Correct, sir.
And just so we're all clear for our jurors, you, Jeffrey Mateer, approved, along with multiple other people in the office, of that particular intervention. Is that true?
Yes, sir.
Okay. We're going to come back to that. I believe you have said that you resigned, and it was on October 2nd, 2020, right?
That's correct, sir.
You resigned because there was no longer a trust between yourself and General Paxton.
That is true, sir.
Okay. And we know that on September 30th, after talking to, or at least some of you talking to a lawyer, you went to the FBI to make a good faith report that you thought a crime had been committed.
Yes, we went to the FBI on September 30th. That is correct, sir.
Where else did you go? Who else did you talk to?
Later that day, we had a meeting with the office of the governor.
Wait a minute. So we're all clear about this. You had a meeting with the office of the governor? Is that what you just told us?
Yeah, we met with the office of the governor sometimes weekly, sometimes every other week. That was normal course. The governor was our largest client.
Right. I'm just trying to figure this out. You didn't talk to, after your meeting, you didn't talk to Ken Paxton. You instead spoke to, 1, the FBI, 2, the Office of the Governor. Who else did you speak to?
I'm not recalling anyone else.
Well, we know you got a text of support from TLR, right?
That was after I resigned, sir.
Did you talk to George P. Bush?
I've never talked to George P. Bush.
Never.
Never.
Can you tell us why he just recently, or I guess sometime in May, applied to renew his law license?
I have no idea. I've never talked to George P. Bush.
Okay, we'll come back to that too. Do you recall that at some point after you resigned that they did an inventory of your office?
Yes.
Now, you're a guy that keeps journals, aren't you?
I keep notes, yes.
Okay, where are your notes in the time frame that you're here to testify about?
At some point, I began using a program called OneNote. The office had provided me with an iPad with the pencil, Apple Pencil. And I started, for my one-on-one meetings, I started a practice that actually I do even through today, although I now use a different program. But I used a program called OneNote. I mean, whenever my written notes end, that's when I started using OneNote. And those were on my iPad that I turned in when I resigned. And I think it's a Microsoft Word. I'm not a tech guy either. I think it's a Microsoft product that was part of the Word suite. And so when I turned in, and it did link to my computer and my iPad, sir.
I don't really understand anything you just said. I'm trying to figure out where your notes are.
Well, you're not representing the Office of Attorney General. The Office of Attorney General would have those notes.
No.
They're on OneNote.
Sir, I'm sorry to interrupt you.
I'm sorry.
You wiped it clean.
I wouldn't know how to wipe something clean, sir.
Well, you know how to delete text, that's for sure, right?
That's just hitting delete and have an automatic delete on your device.
Eric, let's look at AG Exhibit 127 and go to Exhibit 36 within that exhibit. Hope that's not too confusing. This document is in evidence, and we're going to look at what was found in your office and what was not found after you left. Eric, we're going to Exhibit 36 within that exhibit. We're almost there. Now go to the 4th page of that exhibit. We're looking at Exhibit 127, Exhibit 36 to that exhibit, page 3. Now, you can see that in your office, there was an inventory made, right?
Correct.
And we can see that you're a guy that kept a journal, right?
I kept notes, yes, sir.
And we can see that these notes, if you flip back the page prior, Eric, you can see they go from 2018, January, and they go all the way to June of 2020, right? June of 2020. And that's where they stop. Isn't that right?
That's what that reflects, yes.
Where are they?
Where are what, sir?
The notes that are missing.
Again, sir, I began using a program called OneNote. And OneNote, what it does, I know you don't understand, but OneNote, what it does is it's an electronic note-taking system. And you can do it by, and what I had it, the way I had it organized was I had civil lit, I had child support, I had admin, I had criminal justice, I had law enforcement. And so that was a tab. And so it let me more effectively organize my notes by deputy. When I turned in my machines, OneNote was there. It may still be there. I don't know. When I turned in, I lost access.
Who is Jordan Berry?
Jordan Berry is a political consultant who is a political consultant for Mr. Paxton, among others.
Among who others?
Good question. Probably some individuals in this room. I don't know all his clients. So I'd be guessing.
You don't know who Jordan Berry represents?
I don't know all of his clients. I mean, if there's, in this room, maybe Senator Middleton, I
don't want to talk about the senators. I'm talking about other entities that Jordan Berry may represent. Do you know of any?
Other entities that Jordan Berry may represent. I know he represents members of the House.
Entities.
Entities. I don't know, sir.
Don't know. Okay. So I guess we kind of all got to know, when you went to the FBI, what crime did you have this so-called good faith belief had occurred?
The good faith belief that we believed he had occurred was, I believed that he potentially could have been subject to blackmail. And as a result, he was taking illegal actions on behalf of what we then knew was a campaign donor, but he was taking actions on behalf of Mr. Paul.
You believed he was being blackmailed?
At one point, I actually believed he was being blackmailed, sir.
So you didn't think he was committing a crime? You thought somebody was committing a crime against him?
At one point in time, I believed that, yes, sir.
That's why you went to the FBI?
Well, eventually we went because I had tried on several occasions to have, as I think in one of my memos says, that you probably have on here, asked him, I really wanted him to come clean. I even said, are you under undue influence, sir?
And he said no.
He did say no, yes.
He never said, I'm being blackmailed. I'm under undue influence.
But his actions didn't reveal that. When we found out that this woman that he'd had the affair with from years ago, that had moved up to Austin and was now employed by Mr. Paul, and then he was taking these unusual actions. It just didn't make sense to me, Mr. Busby.
I hear you. You made some assumptions, did you not? You made some assumptions.
I made some reasonable assumptions, yes, sir.
You made some assumptions,
yes.
Okay. And you know that sometimes assumptions are wrong, right?
I remember that Odd Couple episode. We're probably similar age. Probably no one else gets that, Mr. Busby.
You believed he may have a potential conflict of interest. That's what you said at some point, right?
You'd have to refresh my memory on that, sir.
You said, I do not have any specific evidence, right?
You'd have to refresh my memory, sir.
Let me ask you something. When you, do you remember there was a hearing in Travis County District Court where you testified?
That by Zoom, I believe, yes.
Yeah.
I was subpoenaed.
And you were asked point blank, let me make sure I get this exactly right, because this might be something that's important to our jurors. You were asked, under oath, whether you believe the AG was engaged in ongoing criminal activity in connection with Nate Paul. Do you remember being asked that question?
I don't think that's the question I was asked, sir.
You don't think that was what was asked?
I do not think that was the question was asked.
Okay. Do you remember, what question do you think was asked? Just so maybe we can refresh your recollection.
I'd love to see the transcript. That would be the best evidence.
Were you ever asked whether you believe that Ken Paxton was engaged in criminal activity?
I don't believe I was ever asked that question during that hearing.
Okay. You believe you were asked about the AG's office itself?
The best, again, if I could look at the transcript, that would tell us all what it was asked.
Let's do that. We're going to look at the transcript from the Travis County District Court, the 250th Judicial District, a hearing that was held on the first day of March 2021. We're going to turn to page 189 of that transcript, Eric. You were asked point blank under oath 6 months after you'd went to the FBI this question. Line 15, page 189, Eric. I'm going to read it. You make sure, tell me if I read it right. And did you come to believe that the Office of Attorney General was being engaged in ongoing criminal activity in connection with Nate Paul? That was the question, correct?
Which is different than the question you asked me.
That's why we're looking at it.
I know.
That was the question you were asked, true?
That is true. Yes, sir.
Let's
You
look
read it
at
correctly.
what your answer was. Page 190, line 15. You said, tell us what you said. If you don't want me to read it, you can read your testimony yourself.
Objection. I don't believe this is in evidence, Your Honor. I stand to be corrected, and if so, I'll withdraw the concern, but I don't believe it's in evidence.
This is House Board of Managers Exhibit 466 that was offered and received by this court. We're looking at page 190, line 15. You said, and I know it called for yes or no, but it's a question that it's hard to give a yes or no. So that makes it difficult for me as the witness. But I would say it could have led to that. Certainly, did I have concerns? I had
Pardon me, I
potential
apologize
concerns.
again, Mr. Busby. Excuse me, please. I think this comes under the heading of, it is one, of course, our exhibits. I don't object to it being introduced, but I don't believe it has. It is not one of those that was agreed to by the parties, and if you recall, they wouldn't originally agree to any of our exhibits, and then we reached some agreements we read in this morning. I don't think it's one of them. So if he wants to offer it, I'm not going to object, but I don't believe this document is in evidence.
Would you like to offer it?
Well, first, it's in evidence, but just to satisfy my co-counsel or a colleague over there, I'll offer it again.
Okay. He did not object.
Yeah.
It's submitted to evidence.
So now let's focus on this document that's in evidence. You were asked point blank, and this is 6 months. I mean, come on. 6 months after you'd left the office, 6 months after you'd went to the FBI. This is after some of your colleagues had filed a very public lawsuit, right?
Correct.
This is even after that you had been interviewed in the press, right?
I believe one time, yes.
Yeah, and all kinds of things were going on in the press about these so-called whistleblowers and crimes and all kinds of things. And then here you are, placed under oath in March of 2021, and you were asked point blank whether you believed the Office of the AG had been engaged in ongoing criminal activity in relation to Nate Paul, and you couldn't even give an answer, could you?
With regard to the Office of Attorney General, correct.
You're making some distinction between the office and the AG himself?
Yes, sir.
Okay. Because you didn't want to say that you had been engaged in criminal activity, right?
I don't believe, no.
I mean, part of the so-called criminal activity is the Midi intervention, isn't it? And you were dead in the middle of that, weren't you?
I approved the executive memorandum.
Isn't it ironic that the first witness called in this case for the House on the first article of impeachment that was passed, that this witness, you, approved that intervention? Isn't that ironic?
I don't know, sir.
Don't you think that really kind of reflects the whole House's case? That they put you up here as the witness to tell us how bad Ken Paxton was, and on the very first article, you approved it. Isn't that ironic?
The irony, I guess, is lost on me, sir.
Is it?
It is.
Before I get to some of these other more difficult topics, would you help us, and we have people watching, and of course, some of our jurors are not lawyers. I want to talk to you about the burden of proof. You know what the burden of proof is, right? You know what that concept means?
I do, yes.
Okay, there's one burden called more likely than not. You understand that concept?
Okay, yes.
What does that mean?
Whether a fact is more likely than not, like the preponderance of the evidence.
Yep, and that's the easiest standard of proof if you're somebody advocating for something, right?
That's the normal standard in a civil court.
Okay, let's focus.
With some exceptions.
Sure, there are.
Turn your microphone on, please.
Oh, there we go. Thank you. I'm sorry. He's not being offered as an expert on the burden of proof, and that's something for the jury to decide in their own mind, his view of what it is or not. He didn't bring these charges. The House managers did. He's not here for that purpose. It's unfair to be trying to, and irrelevant, for him to be being asked what his definition of the burden. In fact, I must say I've never heard that done before. And so I object to it as being totally irrelevant and improper for this witness to be even cross-examined about. What difference does it make what he thinks the burden of proof is, as what they think the burden of proof is?
Wait a minute, Your Honor. With all due respect, this counsel asked this man many times about his opinion on whether law has been broken, many times. And so I'm entitled to ask him about the burden of proof, especially on illegality, which, remember, he sat up there and said that Ken Paxton signing a contract was illegal. So you can't open the door and then close it now.
He has not testified as to what this jury ought to do or how they ought to look at the burden of proof. He was asked whether or not he thought the conduct was unlawful. He said he did, but the burden of proof has nothing to do with it. Those are two different things. The burden of proof is decided by the jurors out there, not this man or any other witness.
I'm entitled to explore why he would say something like that, like in his, what is the burden of proof? And I'm going to get to that if I quit being interrupted.
Overruled. You open that door.
Now, let's talk about the burden in this case for the senators, our jurors. Beyond a reasonable doubt. What does that mean?
Well, it means what it says. It means that you don't have any reasonable doubt.
In other words, any doubts I have are not reasonable.
You know, I'm not a criminal lawyer, but that's beyond a reasonable doubt.
When you went to the FBI and you offered up a good faith belief that Ken Paxton had been engaged in criminal activity, in your mind, was that beyond a reasonable doubt?
I didn't think about that at all, sir.
You just suspected. Isn't that true?
I didn't think about the burden of proof at all in those conversations, sir.
You know, I would think that you portrayed yourself, and I'm not challenging that you were a good and trusted friend, a good and trusted advisor, a good and trusted confidant in some cases, right, to Ken Paxton.
I don't know about confidant.
Well, confidant.
Confidant, sorry about that. Sometimes my speech impediment comes through. I apologize.
No worries, I'm not picking on you. I just want to make sure you understand the concept. I mean, you told us, the entire public, that you had a meeting with Ken Paxton. He talked about his marriage. Told us that, right?
Well, Mr. Paxton, Mrs. Paxton had a meeting with senior staff and talked about their marriage, yes.
Okay, so I guess it brings me to the point. Wouldn't you want to make sure that you were absolutely sure that Ken Paxton was doing something untoward and illegal before you went to the FBI? Wouldn't that be what a trusted confidant would do? Somebody who's a trusted friend, somebody who's been trusted to run the office. At least you should make yourself sure. You know what? Before I do this, because when I pull that trigger, when I do that, all bets are off. I'm out. You even said, I knew when I did that, I wouldn't be the first deputy again, right?
First assistant, yes,
First
sir.
assistant. So shouldn't you be sure before you do that?
Or we were confident.
You were confident?
Yes,
you
sir.
thought that Nate Paul had made repairs on his home?
I had been told that, yes.
Who told you that?
I believe, again, it was either Mr. Wicker or Mr. Rylander.
You think that Mr. Wicker said that to somebody?
Yeah, again, it was either Mr. Wicker or Mr. Rylander.
It seems to me that would be so important. You'd remember who told you that. I mean, you're telling me somebody told me my boss was having a campaign donor pay for renovations of his house, and you can't even tell us who told you that?
Well, I said I believe it's Mr. Wicker or Mr. Rylander, sir.
So if it's not Mr. Wicker, because it wasn't, you're saying it would be Mr. Rylander?
Yes, sir.
Okay. You ever played the telephone game with your kids?
I played the telephone game in youth group, yes, sir.
Yeah.
Not with my kids.
Okay, well, how many kids you got?
I've got 3.
I've got 4. So sometimes I play the telephone game, and you know what that is, right?
I do, yes, sir.
Okay, that's a game where somebody whispers something to somebody else, and then they turn around and whisper something to somebody else, and then they turn around and whisper something to somebody else, and so on, and then they let the last person repeat what they think they were told.
Yes, sir.
And sometimes it's comical how different the story is that's been passed from person to person to person and person, right?
Yes, sir.
Yeah, that's what happened here.
I don't know
A stray comment from Drew Wicker claims he heard that he misunderstood. You, a trusted advisor, a trusted friend, you believe that Nate Paul had paid for the renovations of Ken Paxton's home.
I believe that was possible, yes, sir.
Do you know that it's not true?
I do not know that it's not true.
Have you ever tried to find out?
No, that's why we went to law enforcement, for them to find out.
Why didn't you just ask Ken Paxton?
I had resigned.
You know, he could have shown you the invoices, the wires, the receipts, the samples. You didn't ask him.
I saw them because you had a press conference where you had them. That's when
I only shown a few. I'm going to show them all in this trial.
Okay. I haven't seen them. No,
How many
sir.
times have you told people that Ken Paxton had somebody pay for the renovations of his home? How many times you said that to people?
I don't know if I've ever said that until you asked me the question.
You wouldn't say that to somebody, would you?
I don't have a recollection of saying it.
I mean, you shouldn't say it, should you?
Shouldn't say it.
In other words, you don't know it's true. You shouldn't be out there repeating it, should you?
I don't believe I've been repeating it.
Okay. I think you said, if I'm not mistaken, let me just ask you point blank. You remember you talked about your potential concerns about the office? Remember that question?
From the transcript?
Yeah. Remember that?
Yes, sir.
Okay. You have said that in 2020, you became aware that Nate Paul had donated to Ken Paxton's campaign. Is that right?
That's when I became aware of that campaign contribution.
And when you became aware, you learned, I'm sure, that one campaign donation was actually made in October of 2018, right?
That's correct.
And you learned that October 2018 campaign donation was $25,000, right?
That is correct, sir.
And that Nate Paul was a campaign donor, played a part in your belief that Ken Paxton was engaged in unlawful conduct with regard to Nate Paul, right?
That was part, yes.
Okay, so let's make sure we ferret that out a little bit. You learned in 2020 of a campaign donation almost 2 years before, right?
That's correct, sir.
And the fact that a donation had been made 2 years prior played a part in your belief that Ken Paxton was doing something wrong with regard to Nate Paul. Is that right?
That was part, yes.
Okay. You know who else he gave money to?
Who else Nate Paul gave money to?
Did you check?
No, that wasn't my concern.
Do you know how much money Ken Paxton raised in 2018 for his campaign?
I did at the time. I know it was several $1 million.
What did you say?
I knew I would have known the number at the time. I know it was several $1 million.
Where is that? Where does that blow up? You have it blown up? You know what percentage of, in 2018, what percentage Nate Paul's campaign contribution was with regard to the total amount raised by Ken Paxton?
Well, if your math is correct on this demonstrative, it's there, but I wouldn't have known that then, no.
0.37%. Right?
That's what your demonstrative says.
2018, Ken Paxton raised $6.7 million. Did you know that?
I would have known that at the time, yes, sir.
You checked into that?
No, he would have told me.
And Nate Paul donated 25,000 of that, right?
I know Nate Paul donated 25,000, yes.
And the illegal activity that you complain about, or at least you claim you had a good faith belief had occurred, is 0.37% of that.
If that is the correct math, but I have no reason to dispute you on the math.
So let me just make sure I'm clear. When somebody feels aggrieved and they came to the AG's office to get help, that's the job of the AG's office, right? To help constituents?
That's part of our job, yes.
I mean, isn't that what we taxpayers are paying for?
That's part of our job, yes.
So when somebody feels aggrieved in some way and they don't know where to turn and they go to the AG's office, do you check to see if they're a donor of some sort?
Because of allegations made in the past against Attorney General Paxton, we were very sensitive when we were asked to do things on behalf of folks who had contributed to his campaign. So yes, we were concerned about things like that.
You were. So you decide whether you're going to do your job.
No, sir.
Let me finish my question, please.
Sorry,
if you don't mind.
I apologize.
No worries. You decide whether you're going to do your job based on whether the person is donated to your boss. Is that what you're telling me?
I'm not telling you that, sir, no.
Okay. You look at someone with a jaundiced eye, if they're asking for assistance and they've also given money to the elected official that you're working for?
No, sir.
You're skeptical of somebody who's just asking for help, how to deal with a situation, and you're skeptical because they might also be a campaign donor?
No, not skeptical, no.
Okay.
Sir.
But you already told us that Nate Paul was a campaign donor, played a part in your belief that Ken Paxton was engaged in unlawful conduct. That's what you said under oath, right?
That's correct, sir.
Is it possible, Mr. Mateer, that you jumped to a lot of conclusions really fast?
I don't believe so, sir.
And you could have put all this to bed if you'd just talked to your boss.
I attempted to talk to him starting probably in June, July, August, September.
No.
I did.
Take it easy.
I did talk to him, sir.
Take it easy.
He's not here.
You could have, once you met up with the rest of your colleagues on the 8th floor, you could have then, as the leader, you were the leader, right, of the group?
I was the first assistant.
Yeah, you're the leader.
First among equals, yes.
You even said in your testimony, you said, look, I manage the day-to-day business of that office. Remember saying that?
I did manage the day-to-day office.
And I control the office. Remember saying that?
Control the office. I don't know if I said it in that way, sir.
We'll get to it.
Okay.
But you as the leader, once you heard all these foolishness concerns, some of which you might have believed, some of which you didn't, your job at that point in time was to go to the boss. Isn't that right?
I had tried to go to the boss.
Is it because you wanted to be the Attorney General? Is that what was going on?
Anybody who knows me, Mr. Busby, knows that that is not one of my ambitions. I had my dream job. I came to help Ken Paxton, came down here, a city I didn't want to move to.
Wait, your dream job was to be a federal judge, and that got squelched. Isn't that right?
No, actually, my dream job has always been to be at First Liberty.
Weren't you supposed to be a federal judge, and then the 2 senators objected to you?
What 2 senators, sir?
The 2 that would have the ability to object to you. You know who I'm talking about?
You're talking about our senators?
Yes.
They didn't object to me.
They didn't?
No, Senator Cruz certainly didn't.
Well, somehow something went awry, and you're not a federal judge, are you?
That's absolutely true. My nomination was withdrawn by President Trump.
Yeah. And that's the job you really wanted, right?
I did want to be a federal judge.
Sure.
But my dream job was First Liberty.
Okay. Now, I understand that you took the place of Chip Roy. Is that right?
That's correct.
Chip Roy was the first assistant before you.
That's correct, sir.
Okay, and you mentioned kind of in passing that Ken Paxton at some point became unhappy with Chip Roy.
That's correct.
That Chip Roy was not doing what he wanted him to do.
That's correct.
And he felt the same way about you during the conversation about Kamek, right?
The Attorney General never expressed that to me.
Well,
Has never expressed that to me.
I'm sorry. You told us all that he compared you to Chip Roy, remember?
What I said was Mr. Penley said that.
Penley said that Paxton had said that.
And I asked the Attorney General whether he was frustrated with me, and he didn't respond about being frustrated with me.
Have you seen the second referral from the DA's office to the AG's office?
I may have.
Why would you have seen it at this point?
I had a conversation with Margaret Moore after I resigned, and may have seen it during that conversation. Who was the Travis County District Attorney at the time?
Yeah, I know who she was. Listen, because we're running up against the lunch hour, I want to focus on Midi real quick so we can just put this Midi thing to bed, okay? You going to help me here?
You're asking the questions.
Okay,
I'll answer them.
Let's look at AG Exhibit 151. It's in evidence. And just so the members of the jury understand how the office worked, there's some policy or procedure there that you described as what you could, executive action?
It's approval. It's the title's there, Mr. Busby. See, executive approval, civil litigation membership. He just
executive
highlighted
approval.
It for us.
Sorry, executive approval, civil litigation memorandum.
Yeah.
Okay. We see here the letterhead. Letterhead is Ken Paxton.
I see that.
Okay. And basically it takes us through various people within the bowels of the AG's office who would approve something like this, right?
It starts with someone in the division and goes its way up. Yes, sir.
And this is just found in some policy manual somewhere, right?
Well, it was a policy of the office.
Is it written down?
It is written down, sir.
Okay. Now, so let's just look. With regard to intervention on behalf of the public interest in charity, we have a sign-off of Mary Henderson, who's a senior attorney, right?
Correct.
We have, looks like Josh Godby, who is the chief of the Financial Litigation and Charitable Trust Division, right?
That's correct, sir.
We have also signed off here Darren McCarty, who is, what is he, for civil litigation, head of civil litigation?
He's the Deputy Attorney General for civil litigation.
And then at the top of the chain is your name, where you signed off on June 8th of 2020, correct?
That is correct, sir.
And of course, all of these people here that we see on Exhibit 151 derive their authority from the Attorney General. Isn't that right?
From the Attorney General and the statutes and the Constitution, yes.
I mean, it doesn't matter whether you think it's a good idea or not. He, the Attorney General, is a decision maker ultimately. Isn't that true?
I mean, that authority is delegated down through.
I understand. You can delegate authority, but you can also take it back, can't you?
I think that's correct, sir.
Right. So let's make sure we're clear. Any authority you had only existed as long as you served the Attorney General. Isn't that right?
I think the government code gives the first assistant authority when the Attorney General is absent.
When he's absent.
Yeah, that's correct.
Right. Not when he's on a business trip doing work on a case for Google. You don't get to just say, oh, he's out of town, now I'm in charge. That ain't how it works, is it?
I certainly never did that, sir.
Yeah. And you better not do that, because that'll get you fired, right? I mean, if you were to do that, that should be a fireable offense, right?
Again, as long as the Attorney General were exercising his proper authority as well, pursuant to the Constitution and the laws.
Let's look at why the person that generated this executive approval civil litigation memorandum, let's look at why they thought it was the right thing to do to intervene into this Midi litigation. Turn over, if you would, to page 2 of this document, Eric. I mean, it goes on for several pages with the justification as to why it's a good idea for the AG's office to intervene. Is that true?
That's the purpose of the memo, to set forth the reasons why to take an action.
Did you review it before you signed it?
I did.
Did you have the opportunity to say, I don't think that's sufficient justification?
I would have had that, yes.
And can we agree that even if you thought it wasn't a good idea, that you could be overruled by your boss?
Yes.
Okay, just so we're clear on that, I want to make sure everybody hears that even if, let's say just as an example, using the Midi intervention as an example, if you'd have looked at this and said, you know what, I don't think this detailed memo that goes into line by line of all the problems that the Midi Foundation has had, I don't think that's sufficient justification to intervene. And you said, you know what, I'm not going to sign that. The Attorney General could overrule that however he chose. Isn't that right?
I believe that's correct.
Because you're not in charge, are you?
Ultimately, the elected official is the Attorney General.
Because you've never gotten any votes, have you?
No.
You didn't get 4.2 million votes, did you?
I've never run for any office,
Right.
sir.
He did.
Never any desire.
He did, right?
He did.
Yeah. He's the one that's elected, right?
He is elected.
He's the boss, true?
He is ultimately, yes.
And you serve at his pleasure, isn't that right?
The first assistant serves at the Attorney General's
You're a
pleasure.
political appointee, isn't that right?
That's correct.
And if he doesn't trust you anymore, then you're out the door, isn't that right?
That's correct.
And that's how it works with political appointees, isn't it?
That's correct.
It's at will. When he doesn't trust you anymore, you leave, right?
Or vice versa, yes.
Sure. Let's look at all the problems with the Midi Foundation. Go, Eric, if you would, to page 4, where they're laid out, the bullet points are laid out, the justification of the intervention by the AG's office. Do you see them there?
I see the allegations, yes, sir.
And are those sufficient still in your mind for the intervention?
Again, I approved that memo at the time, yes, sir.
You stand by it today, don't you?
That I approved the memo on that day, yes.
Yeah. Okay. Nobody tricked you to get your signature, did they?
No one on that date tricked me,
Okay.
yes, sir.
And we can see all the problems. They apparently or allegedly the former chairman attempted to conjure a sale of the investment properties in a self-dealing transaction. See that bullet point?
I see it there, sir.
It says that they hadn't filed the proper IRS forms. See that?
Is that the fourth bullet point,
Yes, sir.
I see what it says.
They refused to disclose certain fee agreements, right?
I see that bullet point, sir.
You knew, of course, that one of the individuals who had been involved had gotten in trouble criminally. You knew that, didn't you?
I don't know if I knew that, sir.
Don't remember that?
I do not remember that.
Okay. There's been some saying here. I want to make sure because we're putting Article 1 to bed, which I think puts the whole case to bed. But look at Article 1. Impeachment Article 1, please. It starts off, it says, protection of charitable organization. Do you see that there?
Oh, at the top, yes, I see.
Yeah.
Sorry about that.
I'm kind of doing you like
I
you
was
did me.
reading the paragraph, not the title.
That's false in itself, isn't it?
What do you mean?
AG's office is not there to protect charitable organizations, is it?
No, I think that is part of our role.
It's there by statute. It says by statute, the authority to intervene is to protect the public interest in charity. Isn't that true?
And I think that's what that means.
It's a whole different thing than protecting charities, isn't it?
No, I don't think so, sir.
I mean, the reason for the intervention is because they thought the people within the charity were doing things that were wrong. And so we're protecting the public's interest in the charity, correct?
I don't think they're necessarily exclusive, sir.
You also authorized an investigation of the Midi Foundation, didn't you?
I remember seeing those documents, yes, sir.
Let's see. Keep an eye on our time. I didn't know what time you wanted to do lunch. Is it now? It's a good time to break for me if you want.
Good time for you?
Yes, sir.
All right, we will break until 1:30, 45 minutes.